and by order of a circuit court judge. Termination of parental rights. Before a child can be adopted, if there is a living parent, then the rights to that parent must have been terminated before the person involved can be adopted. There can be a voluntary termination of rights where that a parent comes in and convinces a judge that it is in the best interest of his or her child to give up the parental rights to that child, and that is a voluntary termination of parental rights. There is also an involuntary termination of parental rights, where that the state or other parties have made allegations that the parents are not fit parents for the particular child, that it is in the best interest of the child to have the parental rights terminated. If that allegation is made and if the parents involved deny those allegations, they have the right to a trial. That also is a trial before a judge, but the person has the right in that matter to have a lawyer appointed. If he or she cannot afford a lawyer is appointed, paid for by the state, and is represented at that trial. And then at the conclusion of the evidence, the judge will make a decision as to whether or not the parental rights of that particular child should or should not be terminated. Land disputes. Anytime there is a dispute about the title to real estate, boundaries to real estate, anything affecting the title to real estate, those matters must be heard in circuit court and not in district court. Contested probate. Explain to you that matters which are coming as a routine basis about the settlement of estates and handling people's estates, those matters are generally held in district court. But if there is a dispute, if there is a contest about whether or not there is a will, if there's a contest about the contents of the will, or if there's any other type of contest about the administration of an estate, and there are subject matters to be tried, those trials must take place at the circuit court level. Injunctions. An injunction is where that one person is trying to keep another person or group of persons from doing something, to enjoin that person. The best example of an injunction, if there is an allegation that a nuisance exists, where that either public or privately, one person's activity is interfering with another person's livelihood, well-being, or enjoyment of his or her own environment. And in those cases, an injunction would be sought to prohibit somebody from engaging in a particular type of activity. And a petition for an injunction is filed before a circuit judge, and again, there is no intervention by a jury. The final role that is taken on by a circuit court judge is that even though all the matters up to this point are talking about a trial type of activity, the circuit judge also serves as the appellate court for matters in district court. If a decision is reached in district court on any type of matter, and the parties involved feel that there were errors made, that the law was applied incorrectly, then there is automatically the right to at least one appeal. And appeals from district court must go first to the circuit court. In those instances where appeals get filed from district court decisions, be they in small claims court, regular civil court, or in the criminal cases, there is not a new trial. Many people don't understand the fact that an appeal does not mean that the parties cannot go back before another judge and get a second shot. But instead it means there is a review of the record that was made in district court, and the circuit judge will review that record. He will also give the parties an opportunity to file written papers called briefs, where that the respective positions of the parties would be put into writing. The judge would review those papers, would review the proceedings in district court, and then make a decision as to whether or not the decision in the lower court either should be upheld, or if it should be reversed, or perhaps if it should be reversed and sent back down for a new trial. But the most important thing to emphasize about an appeal is that it is not a second trial. But the circuit court, in addition to serving as a trial court, does serve as an appellate court for matters which come from district court. Now there's the Court of Appeals. In Kentucky we have 14 appellate court judges. Court of Appeals judges are elected the same as our circuit court judges. All judges in the state of Kentucky are elected. The circuit court judges, Court of Appeals judges, and Supreme Court judges, which we will talk about in a few minutes, are all elected for terms of 8 years. District court judges are elected for terms of 4 years. In the Court of Appeals, there are 14 judges, and the way that you arrive at who those people are is that the state is divided into 7 appellate districts. And in each district, we elect 2 judges for the Court of Appeals. So that's how we end up with 14 on the entire panel. But the group does not meet as an entire group, except in very rare exceptions. As a general rule, the Court of Appeals meets in panels of 3. Those panels are designated by the Chief Justice of the Court of Appeals, and they will travel all across the state. And unlike a circuit court judge or a district court judge, a Court of Appeals judge may live in one area but be assigned to hear cases in the completely opposite side of the state. It does not matter where a Court of Appeals judge lives as far as the cases which would get assigned to him or her. They do work in panels of 3. Those panels rotate, so the panel is not the same each time. They will hear cases which have been appealed from decisions made in circuit court. And again, just like the appeals that come from district court to circuit court, an appeal does not mean that there is a new trial, and certainly there is no additional proof presented at the Court of Appeals level. It is just a review of the record that was made in the trial at the circuit court. And the 3 judges will review that record which was made in circuit court. They will review the briefs, which are the written statements and position papers filed by the parties. And then occasionally parties will be given an opportunity to make an oral presentation before that panel of 3. And after the parties have made their oral presentations, presented all of their written papers, their briefs, then the 3 judges will decide whether or not there should be a reversal of the decision made in circuit court. And the decision could well be to affirm the lower court's decision. It could be to reverse the decision, or it could be just to send the matter back for a new trial at the circuit court level. Again, the main thing to emphasize about the Court of Appeals is that it is a reviewing court. It is not a new trial. And another thing to emphasize about the Court of Appeals is that it cannot change existing law which has come about as a result of cases decided by the Supreme Court. I've written here in parentheses the doctrine of stare decisis. That's sort of a fancy term. It just stands for the fact that once law has been established, lower courts must abide by it. That if there is precedent which establishes a point of law, that the lower courts are bound by that law unless changed by the highest court in the state, and that would be the Kentucky Supreme Court, which we're going to talk about now. The highest court in the state of Kentucky is the Kentucky Supreme Court. I told you that the state is divided into 7 judicial areas. In the Supreme Court, the judges are elected for terms of 8 years, and we elect 1 Supreme Court justice from each of those appellate areas. The Supreme Court presides in Frankfort, Kentucky, at the Capitol. Chambers are there. All 7 judges are present when cases are presented to the Supreme Court. Again, the Supreme Court is a reviewing court. It is not a trial court. There are no juries involved. There is no presentation of proof to the Supreme Court. But the Supreme Court will review matters which have come either from the Circuit Court or from the Court of Appeals. Most of the time, cases will have come from the Court of Appeals, and the Supreme Court has the right to choose whether or not it is going to take the case from the Court of Appeals. It's called discretionary review. And the Supreme Court will make a decision as to whether or not any new areas of law are being considered by the appeal that has been filed. If they determine to take the case by discretionary review after it's already been to the Court of Appeals, then the procedure would be that briefs, which are just written position papers by the parties and their attorneys, would be filed. And the parties would be given an opportunity to make oral presentations before the entire group, and then the court would arrive at a decision whether or not to affirm or reverse or send back for trial the matters before them. Now that's the